LLC or corporate entity into your trust. Now you have the best of both worlds. You've got the corporate protection of your LLC, the shield of your corporate liabilities, getting to your personal assets, and in addition to that, you've got a way to make sure that the corporation bypasses the probate process and experiences as little disruption as possible when you pass away. So for my small business owners out there, couple additional concerns you want to be aware of when it comes to your estate plan. 877-943-9673, 877-943-9673. I'm your host, local Central Florida attorney Patrick Smith. This is the Attorney Patrick Smith Show. We encourage you to give us a call now, 877-943-9673. And as always, you can email your questions, Patrick at attorneypatricksmith.com. To reach us throughout the week, you can do so by calling directly to the law office, 877-754-6764. Again, your toll-free number to schedule at any of our office locations, be it down in Sun City Center, where we received an extremely popular reception, and that's largely due to our good friends at 96.3, your community radio, down there, and some beautiful Sun City Center. So if you want to schedule in the Sun City Center office, it's 877-754-6764. The Seminole office location, same phone number, 877-754-6764. You can give us a call. We are happy to get you scheduled. The office will be open on Monday at 8 a.m. bright and early. The office staff will be there to take your calls and book your appointment, and you can come in for your complimentary consultation. But in the meantime, we can talk now, 877-943-9673, 877-943-9673. And again, you can email your questions, Patrick at attorneypatricksmith.com. And speaking of email questions, I'm going to turn it over now to Peter the Intern. Peter the Intern, the floor is yours. Our first email question of the day.
Okay, so our first email question is, my father bought $200,000 in timberland in 2020. My father put the timberland in a life estate for his daughter in 2021. My father's going into a nursing home in January of 2022. How specifically will a $200,000 transfer affect his Medicaid, since that was all the money and assets that he had?
So it's going to come down to whether or not it triggers any sort of look back period. And there's a wonderful attorney that we work with regard to Medicaid planning. His name's attorney Mike Norvell, and he does some fantastic Medicaid planning for us. And we will be happy to put any of you in touch with him if you'd like a complimentary Medicaid planning consultation. And the short version is it's going to depend on whether or not that transaction was a gift, was considered a gift by this life estate, because straight life estate deeds do typically trigger gift tax exposure because it's a completed transaction. So commonly, and you'd have to actually look at the words on the page. A lot of times people say life estate deed when what they meant was enhanced life estate deed, which yields the gift incomplete and could have a different outcome there. So I think the short version to that question is basically get that paperwork together, get with a good qualified Medicaid planning attorney who's going to sit down. And like I said, if you need a referral to one, we'll be happy to give you that information. Sit down with you, review the specifics so that you can know what your exposure is. But there is potential exposure there because in terms of Medicaid planning, it's essentially this three-pronged test. You've got a loved one going into a facility, and you say they have $80,000 to their name. Well, that's not going to cover them forever. They're going to have to burn through this money and then go on Medicaid. Well, not necessarily. There are things you can do to exempt or preserve those assets for that loved one and the family. And that's what a Medicaid planning attorney typically does. But the rubric within which this Medicaid planning attorney operates is basically this three-pronged test of need level, asset level, and income level. And there's exemptions to each one of these three levels. And those exemptions change every October, every April, every 6 months. And that's specifically designed to account for the fact that we have a finite amount of resources here in the state of Florida. And in light of that, and in light of those resources not being infinite, there's only so much money to go around to help those in need. So Actuarially, it has to be designed to tell a certain amount of people that they don't get that access, so that it's available for the people who need it the most. But at the end of the day, within those guidelines, the attorney's job is to reposition the wealth into exempt categories so that the assets are preserved and at the same time not countable for Medicaid purposes. So a good example of that's a case where you have small mortgage on a house, small cash account, and you use that cash account to pay off the mortgage. Having been satisfied, the home now free and clear, and as state constitutionally protected homestead property, which everyone recalls who's regular listeners, we spent an entire show talking about homestead law about a month ago, a little over a month ago, and that's constitutionally creditor protected, and it's a great way that there's no look back period triggered there. That's just a repositioning of assets so that it's exempt. So I think that's the short version, is make sure that you look back at those transactions and see how it would affect any triggering of the 60-month look back period. And if you haven't done any transactions, I always recommend consulting with counsel before you do things. It's better to do that than to have done something and then ask the attorney, well, what have I done exactly? So you get a little more versatility, a little more ability for the attorney to help you if you inquire and seek their help prior to taking any course of action. If you have a question this morning, 877-943-9673, 877-943-9673. I'm Attorney Patrick Smith. This is the Attorney Patrick Smith Show, and we're live and local and happy to help. Open phone lines. We'll get you and your question right on the air, 877-943-9673, or email your question just like that one. You can email it directly to me, patrick@attorneypatricksmith.com, and people ask all the time. They say, do you check your email? Yes, I get my email. They say, well, when we call to set up an appointment, will we meet with you? Yes, you will meet with me. That is the only person that you'll meet with, unless there's someone else you're requesting. I'm not exactly sure who that would be. But at the end of the day, yes, you will be meeting with me. You will be talking with me when you call, and you will be getting me when you send emails. So patrick@attorneypatricksmith.com. Email your questions or give us a call now, 877-943-9673, 877-943-9673. Live and local open phone lines will get you and your calls right on the air. So, and we wanted to make sure that you know that we're available for complimentary speaking engagements. Lots of opportunities for us coming up in the future. We've been booked for numerous events coming up in 2022. And as they get a little bit closer, we'll make sure to announce them on the show, those that are open to the public, so that everyone can mark it on their calendars if you'd like to attend. But if you are out there and you have a group that is in need of a speaker, and you say, oh my gosh, what a fantastic fit, it would be great to have Patrick come out and talk to our group about A, B, or C, we'll be happy to do so. And you can actually we'll customize the presentation for your group. We've done that on numerous occasions, so feel free to do that. And you can make that request and book that complimentary speaking engagement at 877-754-6764, 877-754-6764. So, all right, we got our first caller of the day getting queued up. So while that's happening, I'm going to talk a little bit about a couple of issues that came up this week at the law office, and it had to do with power of attorneys. And it had to do with power of attorneys that were drafted by other practicing attorneys. And the issue that I noticed in these particular instruments was that the documents were not statutorily compliant. Back in October of 2011, there was a major shift in Florida's power of attorney law, and how you do power of attorneys shifted dramatically. The short version is blanket paragraphs are out. You had to be much more specific with your delineation of the powers granted. Special transaction powers had to be called out individually and signed individually. So the document, you can generally tell by glancing at the document whether it's an old version or a new version. 4 pages is about the length of the old ones. The newer ones are 10 to 14 pages. So the newer versions are significantly longer. And at the end of the day, you take a quick look at it, and it doesn't always it's not outcome determinative. If it was an old power of attorney and it was done prior to the statute going into effect, the statute did not retroactively undo it. What we're talking about are power of attorneys that are done after October 1st of 2011, but they are done under the pre-October 1, 2011 statutory requirements. So you want to make sure you have your power of attorneys reviewed. The other situation where this came up was a situation where a person was doing a do-it-yourself document, and that was clearly an error. When you try to do legal documents on your own, my analogy is it's like trying to do insurance or trying to do your own surgery. You would never attempt your own surgery. You would hire a professional. So when it comes to your legal documents, we encourage you to do the same. If you have a legal question this morning, 877-943-9673, 877-943-9673, or email your question, patrick@attorneypatricksmith.com. All right, let's go to Bradenton and talk to John. John, welcome to the Attorney Patrick Smith Show.
Good morning, Patrick.
Good morning, John.
I have a question on liability for a person to protect their estate. Do people put their estates into LLC, personal LLCs to protect from liability, or if you put it into a trust, does that protect you liability-wise?
Well, see, the great thing about being a resident of the Sunshine State is a lot of your assets are already protected. So, John, just so you'll sleep like a baby at night, if you write this down, it's Article 10, Section 4 of the state constitution. That's the section that's going to tell you why your home is constitutionally protected and kind of the scope of the limitations on that. The scope and the limitations, by the way, are not economical, they're geographical. It's 1/2 acre within the city limits and 160 acres or less outside of the city limits. So regardless of the value, that's the homestead protection. For the other stuff that's automatically protected for you as a Florida resident, you'll want to go to myflorida.gov and you can look up Florida Statute 222. Super simple, just 3 2s, 222.
Okay.
And that's going to give you a long list of things that are already protected. So if you have assets outside of that scope, and I'll give you some examples here in a moment, you may want to consider some sort of protective vehicle. LLCs are typically used when it's a corporate entity. It's some sort of rental property, for instance, or it's a small business you're operating. And what's the goal here? We're trying to limit the liability from this rental or from this business so that if it generates a liability, they cannot go after our personal stuff, after the trust corpus. Right, exactly. So that's the goal there. Now, if it's a non-corporate or non-business asset, let's say it's a second home. So say the family has a vacation home in South Florida that's been in the family 5 generations. It's down in Monroe County. Beautiful. So this is a hypothetical. But at the end of the day, this is a home that the family's not going to sell. And if one of the family members has a high liability profession, say they are a physician, there's a high liability there for physicians for malpractice, and there's always a chance they could get sued. Well, if a suit like that occurs and it's successful, it's possible that they could come after that vacation home because that's not constitutionally protected. That's not the primary residence within Article 10, Section 4. So there is the opportunity to create some sort of trust in order to design that trust to provide the asset protection feature. Now, the trust will also carry out the normal, typical features of a revocable trust, meaning avoiding probate, providing incapacity planning, but it'll also have those added features for asset protection. So I think with regards to that, it's really a matter of treating the estate kind of like a snowflake. Each one's individual. And I think that's why we offer that complimentary consultation, is to sit down with the client in the privacy of the office and walk through kind of what all their assets are, what their liabilities are, what their exposures are, and sort of try to put together an optimal plan to best protect the family.
Okay, good. Well, that sounds all right. Thank you very much for your answer. That tells me, it helps me out. Thank you.
All right, John. Thanks for calling in. We appreciate you. All right, you're listening to the Attorney Patrick Smith Show, and I'm your host, Attorney Patrick Smith. 877-943-9673. 943-9673. Give us a call now. We're live and local. It's just as easy as John made it look. And by the way, congratulations, John. You're our first caller of 2022. It was a great question. Kind of ran the gambit of small business application, LLC application, trust law, and avoiding liability. So, I mean, a fantastic question, John, to start off 2022. It was almost like a law school fact pattern. So, if you have a question, 877-943-9673. Give us a call now. Open phone lines, 877-943-9673. Or email your question, patrick@attorneypatricksmith.com. patrick@attorneypatricksmith.com. Feel free to give us a call now, and we will be very happy to answer your question live on the air. All right, let's go back to Peter, the intern, who's going to read our next email question. Peter, the floor is yours. Go ahead.
So this next question is, my home is in my name only. Does my husband automatically get the house if I pass away first? I have a home that I worked and paid for prior to getting married 10 years ago. I would like for my husband to be able to continue to live there if I should pass away first. However, I would like for my son to own the home once my husband passes. What would I need to do to assure that this happens?
So the short version is you would have to execute a document known as a prenuptial, or if you're already married, a postnuptial agreement. Because without that, there's going to be state statutory rights. Now, the concern at the start of that question about the husband, does he get it outright immediately? No. If the child in that situation was common, meaning it was the child of the husband and the wife, and there's no other children besides that child, in that particular scenario, yeah, the husband could take the entire home. But in this particular scenario, it sounds like the child's from a prior relationship. So in that case, what's going to happen if no planning is done and the home, which is just in this wife's name upon her passing, the husband will have two choices to make. Number one, if he does nothing, his default position is he will take the right to live in this home for the rest of his life. It's called a life estate. And then the remainder interest will go to the child, the child of the deceased wife. Option two, and I believe this amendment to 732-401 came down the pike in 2010, allows the spouse to file what we call a tenant in common election. And this tenant in common election must be made within 6 months of the date of death. A lot of people make the mistake of thinking it's 6 months from when the estate administration begins. That is not the case. It's 6 months from that date of death. So if you have a situation like this, you make sure to mark it on the calendar to know that's your deadline for making the election, to take that tenant in common election. Well, what happens if I take this election, Patrick? Well, what happens is you forego the life estate. You irrevocably give up the right to live in the home, but you take half the value of the house now. So you walk away with half the cash. Now, in our scenario, in the question, that's obviously in contradiction to what the wife wanted. She wanted husband to get life estate, and then for the remainder interest to go to her son upon her passing, which is the first option, but there's no guarantee. The husband may make that tenant in common election. Well, how do we assure that that's going to be the case? And that's where the prenup comes in. So with a good prenuptial planning, and there's actually statutory provisions for homestead waivers now, you can say, essentially, we're going to waive our rights to inherit under homestead, and we're going to give each other permission to do whatever we would like. Now, years ago, and I've seen some of these cases where essentially you see it drafted, especially prior to 2010, where they say the house is in just the wife's name, and upon the wife's passing, we know the husband's going to get the life estate. Because remember, this is prior to 2010, so that was all that was available. There was no tenant in common election at that time. So the draftsman in this case says, we're going to go ahead and give the husband the life estate, but the remainder interest is going to go to the church or something else, someone else. And what happened there is those are invalid devises of homestead. And where property is invalidly devised, you go by the statute, you go by the intestacy, 732-402. So in this case, the people who should have taken after that husband's death, be it a church or entity of some kind, they're not going to take because it was invalidly devised. Because even though husband got life estate, the remainder interest goes to those lineal descendants. So the only way to override the statutory provision is to have a knowing waiver under 732-702 of those statutory rights. Then you can put it in place and say, now we're going to have life estate to the husband, remainder interest to the church or whomever you want. The prenuptial agreement does not stop you from leaving assets to your spouse. It just allows you to climb out from underneath any burden that the state statutes or constitutions place on you. Now, talk about another common bear trap we see. Here's the other bear trap. So someone has taken the time and the effort and they've gone through creating this prenuptial agreement or postnuptial agreement. They've created the trust. It's time to put the home that's in just the wife's name into the trust. And they do so. And the wife alone signs the deed. Is that valid? No. Why? Because the spouse did not join. And you say, Patrick, the spouse just signed a waiver of his rights. That's right, he did. He signed a waiver of his rights to inherit the property. But the state constitution under Article 10, Section 4, subsection C says that the homestead property, and this will be reviewed for some of you who were listening a few weeks ago, may be alienated or transferred with spousal joinder. But it's the converse that demonstrates the rule again. It may not be transferred without spousal joinder. The nuptial agreement had no effect on that. So here, with the wife transferring the property to her trust, the spouse should still join in that conveyance in order to make sure that the funding of the home into the trust is statutorily compliant. So lots of potential bear traps there when you get into these, we call them non-traditional marriages, and by non-traditional we mean second or third marriage, something of that nature. And we have a blended family scenario. So extra additional caution needs to be paid in those situations. Maybe you're in such a blended family scenario and you have a question. 877-943-9673. 877-943-9673. Absolutely fantastic email question, by the way. 877-943-9673. Give us a call now. We're live and local. Open phone lines. We'll get you right on the air. You can email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. So feel free to email your questions now, and we'll also answer your email questions throughout the week. And a lot of you take advantage of that, and I really appreciate it. I really appreciate all the kind words, and those of you who just take the time to shoot us a quick email to say you love the show and you appreciate what we're doing here. We can't respond to each and every one of them, obviously, but we read them, and we thank you so much for all you do to just support us and buoy us with your thoughts and prayers for your support for the show. So thank you from the bottom of our hearts for everything you guys do for us. 877-943-9673. 877-943-9673. Feel free to give us a call now, and you can get right on the air with your question or email your question, patrick@attorneypatricksmith.com. I was talking to an accountant this past week, and he was informing me that there is a provision in the tax code that I think is going to be relevant to a lot of small business owners. The show's sort of taken on the small business owner tilt today, so this brought this to my mind. There is, when we have the CPA on, I'll let them elaborate in a little more detail, again, because I am not a CPA, I'm not a tax advisor, so I caveat this statement with that. But apparently, for those of you that may have started a business within the past year during the pandemic, there's a tax credit available, which is $7,000, I believe, per employee per quarter. So that can really add up. So make sure if you started a business within this last year, you sit down with your CPA, and if you don't have one, we'll put you in touch with several that'll be happy to give you a complimentary consultation. But make sure you take advantage of those credits if applicable to you. But that came up recently in a conversation with a small business owner, and wanted to make sure I passed that along to you guys so that you could follow it up if you're a small business owner, especially a small business owner that started your business within the last year. So 877-943-9673, 877-943-9673. You can give us a call now or email your question, patrick@attorneypatricksmith.com. patrick@attorneypatricksmith.com. All right, Peter the intern had no idea I was going to do this, but since the calls are a little slower than usual, we're going to fire away a question at Peter the intern. Let's just see how he does, because maybe one day Peter the intern will have his own radio show and he'll have to answer questions. So we might as well practice now while we have the time. So Peter, I want you to explain to the listening audience the difference between a financial power of attorney and a healthcare surrogate. Go.
So a financial power of attorney handles things such as signing checks, paying bills for, say, the person was in the hospital, getting some sort of surgery done. The power of attorney, you'd be able to sign for different things like that, for paying those different types of bills. And a healthcare surrogate gives you power over to make a choice for someone if they are going to get that surgery, if they're going to get this done. If there's no living will in place, I believe if they could pull the plug, if there's no brain waves or anything like that. So financial handles paying bills, signing for credit cards. Healthcare surrogate handles the choices on surgeries or things like that.
Well done, Peter. And for those of you listening, Peter's not a licensed attorney. That's why we call him Peter the intern. Although, let's be honest, even after he is a licensed attorney, he's already accepted the fact that he's going to be Peter the intern for life. So, but at this point, he holds no law license. His answer is correct, though. The financial power of attorney covers all the financial matters associated with banking and any sort of investing, stocks, bonds, CDs, brokerage funds, things of that nature. The healthcare surrogate addresses any healthcare decisions, obviously, but also the person. The person's physical being, where will they go, what sort of treatments will they get, and the follow-up question to that, Peter, is what if I want it to be the same person? Can I combine it into the same document, or do I have to do a separate financial power of attorney and a separate healthcare surrogate?
So if you wanted two separate people to be, like one person to be the financial and one person to be the healthcare, then you could split them up. But in the power of attorneys that we do, and in most power of attorneys, I believe, there's a clause on the 13th page discussing the healthcare powers, so it can be the exact same person.
And for those of you out there, if you aren't clients of ours and you look at the 13th page of your document, it's not there, don't be disappointed. It's not that uniform. Peter's just referencing our specific instrument because it's the only devil he knows at this point. So, but for those of you scrambling with your documents, looking at page 13 right now, saying it's not there, it's okay. That's an easy fix. But if we didn't prepare it, it's not going to be on page 13. But that is correct. You can combine it, you can separate it. The situations where we see it combined, that's where, it's an only child scenario, so, mom wants this child to do it all. Or if it's split, that's usually where, the son's the vice president of a trust company, and so he's going to be the financial power of attorney. And the daughter is a physician, and she's going to make all the medical decisions. Or can they just combine them, Peter? What if they want the kids to do the decision making together? Can they do that?
Yeah, so if they wanted the kids to do the decision making together, it could be and. So it could be John Doe and Jane Doe. Or if they wanted them to both hold the same amount of power, but not have to make these choices as one, then it could be or.
So, in a scenario where you wanted to give power of attorney for finances to son, and healthcare surrogate to son, and a financial power of attorney to daughter, and a healthcare surrogate to daughter, you need not do 4 separate documents. You can combine all that into one simple document. Streamline it, keep the costs down, make it much more effective. Great job, Peter the intern. 877-943-9673. 877-943-9673. Give us a call now. We're live and local. We're happy to help any way we can. You can email your question like that one. Well, two emails ago. Patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. You can email your question and we'll be happy to answer it live on the air. And again, for those of you who just want to schedule an appointment, and lots of you do, at the rate we're booking appointments, I think on Monday we have 33. We're up to 33 appointments. Peter, the intern, just told me on Monday. And I have the most amazing staff in the world, and that's why I'm able to pull off meeting with 33 clients individually, and handling each client's needs specifically, and making sure that they're given the very best care and attention. But I could not do that without my amazing staff, and they are excellent. They are second to none, and they allow us to pull off that and maintain the sort of volume that you guys are demanding of us at this point. So if you want to join the crowd and schedule an appointment, 877-754-6764, 877-754-6764. Monday through Friday, the office is open 8 to 4:30, and any of the young ladies who answer there, whether it's going to be Megan, Savannah, Becky, Alyssa, any of them who answer will be more than happy to get you scheduled for your complimentary consultation. We also do phone conferences. That came up this past week. A gentleman came in, ailing family member, and said, Patrick, she really needs to get this stuff done, but at the end of the day, she just can't come into the office. And so we're doing a conference call, and we do out-of-office visits as well. So conference calls, out-of-office visits, all available. So if you need to take advantage of that for someone who's infirmed and unable to physically come into the office, we can, of course, be sensitive to that. 877-754-6764 is your number to set up that in-office appointment or complimentary conference call, whatever you'd prefer. 877-754-6764. And you can email your question again to me directly, or email for an appointment. Have lots of people doing that as well. Patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. Email to set up your appointment. Email with your question, and we'll be happy to do the very best we can to get you in as quickly as possible. But to be part of today's show, 877-943-9673. 877-943-9673. Give us a call now. We're live and local, and we have some very big news I'll announce here a little closer to the end of the show. I teased it last time I was live on the air. I was off last Saturday. Took our family on a wonderful vacation. We were able to get down to Costa Rica and enjoy the Christmas holiday down there. And I'm going to make good for those of you who remember the tease of the big news announcement about the show. So don't worry, we're going to make good on that promise and tell you about that information. But before we do, let's go to Tampa and talk to David. David, welcome to the Attorney Patrick Smith Show.
Good morning.
Good morning, David. How are you today?
I'm well. I didn't do any partying, so I'm awake. I can call your show.
Well, you and I are in the same club, David. So woke up bright and early, 6 a.m., as spry as could be. So.
Very good. I've got a question. I'm planning on probably getting married here soon.
Congratulations.
And I've got a few thank you. I've got a few properties, however, and I don't want, I don't know if a prenup is the best way to go, but I'm thinking, what if I just put these properties in a trust and therefore don't own them? So in the event I do get married, if there were some problem, some future date, they wouldn't be subject to, to losing them. So that's a question. And a second part of that is, would each property be in a separate trust? Thank you.
I don't think you would have to create a separate trust. I mean, if these are rental properties, I would probably advise you to consider LLCs for them and then put the LLCs into the trust. But again, my concern with the transfer of the asset to the trust in order to protect it from the future spouse is the trust at that point is going to have to be irrevocable. As you noted, you're not going to be able to own it at that point. Well, the irrevocability of that trust, the inability to change it, locks it in, and that makes it a completed transaction, or in the eyes of the Internal Revenue Code, a completed gift. Now, this is a huge difference between revocable trust and what you're talking about, David, an irrevocable trust. With revocable trust, which is what is commonly used in modern estate planning, it's revocable. You can change it. That means the gift is incomplete. There's no gift tax owed because things could still change. You could change beneficiaries, assets, trustees, lots of moving parts. With the irrevocable trust, you're basically locked in at that point. And because of that, that's completed gift. So I would advise you to make sure, if you do that strategy, consult with your tax professional, preferably a good CPA, to make sure you've accounted for the gift tax consequences. And if the sole goal is to protect from a spouse, I think that's probably worth a conversation about a nuptial agreement as opposed to the irrevocable trust model, just because it would give you more access to your own stuff if the spouse is willing to agree to the nuptial agreement. You don't have to irrevocably and forever give up these assets if the spouse is willing to agree to the postnup.
Right, and it does seem immediately knee-jerk for me when I'm hearing this. Well, if I'm doing that, even though I'm home, I've had it for more than 2 years, so I'm not going to be taxed on any, growth, and there is quite a bit of growth in two. I would still then, by gifting it, there would be a tax implication. It sounds like, and then of course I would lose the the growth in it if I were to sell it. You know what I'm saying? I would be taxed then on the growth.
Yeah, and you would, and I think you would lose your homestead exemption as well if you transferred it to an irrevocable trust, because then you wouldn't own it. So I think you'd have to account for the additional property taxes, the gift taxes, and again, I think, anytime you look at a major shift or a major life choice like this, I always recommend bringing in that triumvirate of professionals in your life: your attorney, your CPA, your financial advisor. And usually having a good call with all three of them, maybe individual calls leading up to a joint call with everybody, is just going to sort of optimize the Davids of the world when they go into these new situations in life, like a new marriage. So I think that's probably your safest bet. But again, the postnuptial is probably going to give you the most versatility. And again, on postnups, when you present a future spouse with a postnup, sometimes what they hear is, "Great, you're already planning on divorcing me," and it's really not that. I mean, back in the '80s, the postnup and the prenups had that connotation. It's really been on this track for the last 40 years of kind of merging, or at least transforming, to have this permutation that's really an arm of estate planning with regard to waiving spousal rights under elective share provisions, or waiving homestead rights under the state constitution. So it doesn't have to be this sort of pre-divorce game or plan of attack. It can be truly an extension of the estate planning document. So it's not as intimidating as it used to be, but a lot of people take it that way. That's why when you bring this up with a spouse or future spouse, sometimes there's that immediate recoil. But it's not.
Well, no, we're all on. Not to interrupt you. We're all on board with it. It's just, I would think that if there's a willingness to do a prenup, wouldn't that be more, kind of taking care of business before you're trying to do it after you're married?
Well,
that make more sense?
Yeah, I like prenuptial agreements because I think it shows a better plan going into it. Although I think postnups are just as effective. And I think that either way, you want to do full financial affidavits and disclosures and consultations with clients about nuptial agreements. Sometimes they'll say, "Well, do I have to tell my spouse about this? I'd kind of like to keep this private." Well, when you are talking about nuptial agreements, you're talking about saying that your spouse made a knowing waiver to your assets. If you don't disclose the asset to your spouse, how can you demonstrate that the spouse made a knowing waiver to that asset? So I think it's important, and I encourage you not only do the prenuptial agreement, but also make full financial affidavit disclosures in those nuptial agreements, because I think it also further strengthens the document. I also think it's best if you and your fiance each have separate counsel. And the last thing I'll tell you about nuptial agreements, as far as making them as absolutely strong as possible, try to do them in as far advance of the wedding date as possible. What you don't want is a scenario that's, you're in the limo on the ride to
Right.
the church, and you say, "Oh, by the way, before we head down this aisle, do you mind signing here real quick?" Obviously, there's some coercion involved there. So, but the point stands: the further out from the actual nuptials, I think the stronger the document based on current case law.
Very good. Thank you so much.
David, by the way, do you have an officiant for the wedding yet? Oh, David hung up. Oh, David, if you have not an officiant, allow me to offer my services complimentary, absolutely free of charge. It's my wedding gift to you and your bride. I've done 2 weddings so far, and both were at the office. And I'm looking for number 3, sort of a little side business. Although I've never made a penny doing a wedding, I figure if lawyers can do divorces, why can't lawyers do weddings too? So I've done 2 weddings, and I've done no divorces. So I look at it that way. I feel pretty good about that. But at the end of the day, I think it's a beautiful thing. Congratulations to you and your bride, David. And now we have a couple minutes here left in the show. So the big news, as promised, beginning in February, we will be adding an 8th station to our family of Attorney Patrick Smith Show listeners. So moving up in the world. My goal is 10, by the way. People ask me, how many stations do you want to be on? 10. It just sounds good. It's a good round number. But nevertheless, number 8 that we will be adding in February is none other than 102.5 The Bone. So we actually signed the contract this last week. We will be going in on the air on The Bone on the first Saturday in February. So get ready for that. We'll be adding an 8th family member to our family of stations, and we could not be more excited about that. And yes, for those of you getting ready to call in and say, that's not what we wanted. We wanted another hour of the show. I understand. At this point, this opportunity came available, so we took this one first. But we are aware of your desire as well to lengthen the show. So stay tuned, say a special prayer for that expansion and adding our 8th station onto our 9th and ultimately onto our 10th station. So we're very excited about working with 102.5 The Bone and all the rest of our 7 stations that we're currently on. And special thank you to all the Salem family for making it so easy to add another family. Like, I really thought it was going to be difficult, but I called Joe Weaver, our programming director here, and he's like, easy, got this. And I was like, all right. So but that's what you get. The Salem family here is absolutely amazing. So couldn't say enough great things about everyone here. So the number 877-943-9673. Just write that down for next week. We're under a minute here left for the show. So next week, if you have a legal question, call in 877-943-9673. Or if you want to visit me at the law office during the week, give me a call. 877-754-6764. 877-754-6764 for your complimentary consultation, or you can give me a call on the air. You can email me directly, patrick@attorneypatricksmith.com. Email me, patrick@attorneypatricksmith.com, and we'll be back with you in 2 Saturdays. So stay tuned. Everyone have a wonderful Saturday and be safe.